submitted by the state, especially with the language in Forsyth County, referenced on pages 10, 13, and 14 of the state's brief. And nothing further.
All right. Thank you, Ms. Weise. I had a couple of questions, several questions that I wanted to ask you. On page 4 of your brief, you indicate that ordinarily when we're dealing with a constitutional issue, the burden is on the person challenging the provision to establish that it is unconstitutional, but it seems you're acknowledging that when a statute or rule implicates the First Amendment, and certainly that's the claim here, as you say, the burden shifts to the government to prove beyond a reasonable doubt that the statute passes constitutional muster. And you cite the Stevenson case. Do you continue to adhere to that belief that the burden is on the state to prove beyond a reasonable doubt the constitutionality of the rule?
As noted on page 4 of the brief, yes.
Okay, all right. Do you also agree that the rule at issue effectively creates a permitting requirement in that the rule says that a participant or spectator within a group constituting a lawful assembly who intentionally fails or refuses to withdraw after it's been declared unlawful shall be subject to certain penalties. And then it says that an event may be declared unlawful if, and among other things, number 5 is the provision here, enter or occupy a building or facility managed or leased by the department with authorization. So what this amounts to is in fact a permitting scheme that the department has established that requires prior authorization through a permit in order to participate in an event in the rotunda. Is that fair?
Yes.
That's what we're dealing with? Okay. Mr. Olson says that as he perceives the issue, and I think I agree with him based on reading your brief, you don't argue with Judge Conley's decision in Kissick. In fact, you urge me to follow that and effectively adopt it, correct?
In this case, yes.
Okay, well you say in this case, but it seems to me that the state's position is the state's position. So you're urging me to follow Kissick.
Correct.
Okay, now in Kissick, Judge Conley said that the provision of the rule that Mr. Olson is challenging here, that on its face, there is, as he put it in one point, a fairly strong likelihood that the plaintiffs had success on the merits of their constitutional challenge. In another place, he flatly says that he determines that the provision is unconstitutional, or the access policies are unconstitutional in 2 respects. And yet at a third place, he talks about there being a strong likelihood of a determination of unconstitutionality. So, as the rule is written, the state shares the view, apparently, that Judge Conley is correct in his assessment that there's a pretty good likelihood that this rule is unconstitutional.
The state has addressed that in its written submission and continues in that in the brief that was submitted.
Okay, so just to be clear about it, you agree that as written, the rule is unconstitutional on its face because it's not, as Judge Conley said, narrowly tailored to meet the specific objectives that the state identified and established at the hearing in that case. Is that correct?
I don't think that's what the brief says. As it has been employed, or as the rule has been employed by the Capitol Police, it does meet the standards that Judge Connolly set out.
Okay, I understand that that's your position, but
Right.
that's the only way that this rule can be sustained, if I understand your position, is to graft onto the rule, if you will, or read the rule as specifically being limited by Judge Conley's injunction, which said that the rule couldn't apply to groups of 20 or fewer.
That's correct.
Okay, so that's the reason that you think the rule passes constitutional muster. Now, I guess then we move to the issue that Mr. Olson raises. I guess first of all, that would imply that any citation that was issued before Judge Conley's ruling, and before presumably the state decided to follow that ruling, that the rule would be unconstitutional with respect to an earlier citation that preceded the ruling. Is that correct?
I don't know that that has been decided. It's the state's position that Judge Conley's decision was not the end decision, that it was a temporary injunction, and the citations issued after that temporary injunction did follow Judge Conley's rules.
Okay. What about the one, and there is one here today, and I get a little bit ahead of myself here, but as to that one, before Judge Conley had an opportunity to rule, you've agreed with me that Judge Conley determined that the rule was unconstitutional, and your position is unless it was de facto modified by Judge Conley's ruling. But obviously, as to any citation that preceded the ruling, if Judge Conley was correct, that citation would have been issued under an unconstitutional rule.
If Judge Conley is correct, that's right.
Okay. Now, let me ask you this. The department had an opportunity following Judge Conley's rule to amend the rule, right?
I assume so.
Okay, and that could have been done on rather short order because they had adopted this rule in the first place as an emergency rule, right?
Okay.
Okay, so it wouldn't have taken a long time to get it done. Why didn't the department, if their position was that they're going to follow Judge Conley's ruling, that the rule is constitutional, if you imply Judge Conley's ruling into the rule, as it was then written, why didn't the department simply amend the rule?
Your Honor, I don't have any information available to me in order to answer that question.
Well, Judge Conley says that, and I'm quoting from a paragraph that's labeled 19 here in his opinion, said another way, permits chill speech. Both the procedural hurdle of filling out and submitting a written application and the temporal hurdle of waiting for the permit to be granted may discourage potential speakers. You acknowledge that that's a part of the decision and that that's well established as a matter of First Amendment law.
That is part of the decision, yes.
So, given that the permitting process chills speech, isn't it important for the public to know what is and isn't going to be permitted in a public space like the rotunda, so that they can make a decision, an informed decision, whether they're going to participate in something that may get them into trouble, may not get them into trouble. They may choose to undertake the risk that they're going to get into trouble, but that's a risk that they would then undertake knowingly and knowing exactly what the rule is.
Right.
Fair statement?
Yeah.
So, if after Judge Conley makes his decision, if I'm thinking about going to the Capitol Rotunda to sing, the rule isn't changed. Where am I going to go to find out whether the department's going to enforce the rule as it's written, the rule as in light of Judge Conley's decision, where he enjoined its enforcement with respect to groups of 20 or fewer. Where am I going to go to find that out?
You know, Your Honor, I don't have that information in front of me. I can speculate as to different areas, venues, with my own personal familiarity of the Capitol as to where you could go to find those things out.
Well, we know that if I went to the rule itself, that doesn't help me, other than I know that the rule doesn't contain any numerical floor, and I could be there by myself, I could be there with a couple other people, I could be there with 20 people, who knows. I'm subject to enforcement of the rule. I suppose one place I could go would be the access policies. Right?
Okay.
Okay, I think you attached these to your brief, and those are interpretive policies that the department issued as to issues concerning access to the Capitol Rotunda. Is that correct?
Yeah, which one was that? Was that exhibit?
This is Exhibit E to your brief,
Okay,
Wisconsin State Facilities Access Policy.
Mm-hmm.
So there would be one point that I might go if I were in that position and wanted to know whether the state was going to take action against me for singing or not, or under what circumstances. It would be fair for me to look at that policy.
I think so.
Okay. And what that policy says, if I read it and got to this part, and this is, I guess, 3J, it says permits are required for any rally consisting of 4 or more persons occurring inside the Capitol, right?
That's correct.
So the policy doesn't even apply. It says that I could be, if I participate in an event in the policy, in a rally, pardon me, in the rotunda with as few as 4 people there, that would, and I didn't have a permit, that would subject me to punishment.
That's what it says, yes.
Okay, and that's different from the conclusion that Judge Conley reached, that the rule could only, at least, and I have to be careful about how I say this, but what he was saying was that he would enjoin its enforcement for groups of 20 or fewer because it's likely that the rule would be constitutional with respect to that small group of people, and the number he chose was 20.
Okay, right.
So if I went to the access policy, that would take me to a place where Judge Conley said that policy would be unconstitutional.
I don't think Judge Conley reached the final decision regarding constitutionality. He did issue a temporary injunction that was followed by the administration.
But I guess what I'm thinking as I look at this is I can't go to the rule because the rule doesn't provide any greater guidance in terms of what Judge Conley said. The access policy is distinctly different from what Judge Conley said, and in fact, even the access policy setting the floor at 4 would, as he would determine it, be likely unconstitutional because it applies to such a small group. So, can you see the position that this might place people in, that they don't know until the department actually does something to amend the rule whether their conduct is going to get them in trouble or not?
Your Honor, I think that's sort of stretching the point. I think that somebody wishing to conduct an event or take pardon event has the ability to approach the information desk or any other official that is readily available in the Capitol to clarify whatever rules are in place at that time.
So is that what the state is contending, that the person who has a serious concern about whether this is going to, what's going to happen if they do this, should ask somebody at the information booth in the Capitol what the law really is?
Or merely go and get a permit, yes.
But they shouldn't have to get a permit if it's for a group of fewer than 20. That's what the Constitution says, according to Judge Connolly.
I don't know that the Constitution says that, according to Judge Connolly. I know that that is what the temporary injunction imposed with the settlement agreement between the parties, and that's the number that they agreed upon with the settlement agreement. There was no final decision.
Actually, they didn't, even in the settlement agreement, they didn't incorporate the floor of 20 that Judge Connolly made a part of this injunction. Is that true?
Yes.
Okay. Given that the state's position is that whether enforcing this rule against people following Judge Connolly's decision depends on the state's decision to follow Judge Connolly's preliminary injunction, and given how the acknowledged chilling effects of a permitting requirement on the exercise of free speech, can you point me to any authoritative source that would be readily available to somebody who wanted to do this but wasn't sure what they needed to do to comply with what the state thought the law was?
For instance, I'm wondering, Your Honor, what you're asking.
Well, if you were a lawyer advising somebody and the person said, you know, I'm thinking about participating in this activity. We're going to do it in the rotunda. You look at the rule, and you would have to say, based on the rule, state could require you to get a permit even if you were just by yourself. Okay? That's true, isn't it? Just the rule.
I don't know that that's been established, but it sounds correct.
Okay, and then we look at the access policy, then it's, well, as long as it's 4 or fewer, we're not going to require a permit, but more than 4 we are. Okay? So how do you advise that client, even after Judge Connolly's decision, what position the state is going to take about when they're going to require a permit and what kind of activity and what number of people gathered together is going to invoke the permit requirement even after Judge Connolly's decision? What do you as the lawyer say to a client who's wondering, as he or she would have a right to do, whether this engaging in this activity is going to cause them problems?
I would advise my client to get a permit.
Even if it were